Africa was both chairperson of the African Ombudsman Research Center, as well as executive secretary. At the time, the position of Secretary General was called Executive Secretary of the African Ombudsman and Mediators Association. So she signed in her capacity as Executive Secretary of AOMA.
Good. And all right, now let's go back to 266. Thank you. And against this, before I ask you specifically, when I was asking you earlier about the importance of these international institutions, the word that you used the most was the word protection. Why is that an important issue, the issue of the protection of incumbents or ombudsman offices?
As I explained earlier, the institution of the Ombudsman is very unique in that it is a creature of political will. The government of the day has to allow for the institution to be created. Of course, public awareness, also increasingly public awareness, and a call, just a general call from the people for an institution which supports the ordinary man has also helped. The wind of change of democracy has also helped to instate this institution in various countries. But once the institution is created, there are a lot of underlying problems in order for the ombudsman to be able to operate independently. So you can, if you look at all the instruments that I have quoted, not just the OR Tambo, the Venice Principles, the IOI bylaws, the United Nations resolutions, they all talk about the need to protect the independence of the ombudsman, because the ombudsman investigates the very office which created it and the very office which funds it and the very office which is supposed to pay the salary of all the salaries of the members of staff and the ombudsman himself. So you find, I think I can speak from experience, you find that the institution of the ombudsman will not be properly funded. It will probably be the least funded. And yet the institution is supposed to investigate the executive, whether it's parastatals, whether it's ministries, ministers, PSs, permanent secretaries. This ombudsman is supposed to investigate all these people. So the first thing you find that there is underfunding. The second issue, maybe you find that, which happened in my case, the ombudsman reports to the executive. And if the government does not accord the ombudsman the appropriate status, you will find that the ombudsman is in the civil service salary scale, and the head of the civil service is his boss. And when the officers from the ombudsman go to investigate the various officials, they are even threatened and told, how can you investigate your boss? You know, and you find that a lot of the members of staff in some instances are drawn from the civil service. So the members of staff start to fear that I will not be promoted, I'll be demoted, because they are within the structure of the civil service. So it became necessary to set up standards to say, even the staff of the ombudsman must be appointed by the ombudsman and must be not drawn from the civil service. So other threats to the institution include also reprisals to the ombudsman himself, political reprisals to the ombudsman himself. So the conditions of service of the ombudsman may be tampered with. You may find that the ombudsman is not able to, even if he has the powers to access documents and other things, he may not be able to access documents, even if it's in the law, but it may not be possible. So you find that in a lot of jurisdictions, they say the ombudsman is a toothless dog, because they say that the ombudsman is supposed to be the public service watchdog. But the executive which establishes it is the one that is supposed to give it teeth.
Yes.
And by its very nature, and this is the reason why in the classical example, the ombudsman reports to the legislature in order to separate the issue of the ombudsman having a conflict of interest, being accountable to the very office it was established to investigate.
Yes. Thank you very much. Well, if we can just pause on that, and that I'll just ask you to maybe, insofar as you may, comment on this, because that issue that you have raised features very prominently in this inquiry that we're having here in various ways. But let me just give you one example. And as I said, we are a young democracy. Maybe we can learn a thing or two, and maybe we can make the necessary adjustments. Learning also, and everyone has accepted here that this process is also for us to learn as a country. Now, in our situation, against the background that you have mapped, we have a strange situation where a member of the executive, for example, is given the power in terms of section 194(3)(a) to suspend the public protector, basically in his or her own discretion, even in a situation where the public protector is investigating that person. Is that a good thing that is in line with the protections that you are talking about at a general level? An unfettered power to suspend at the hand of the executive. And if I will give you a comparative situation with judges, where that situation is quite different. But as far as the public protector is concerned, there isn't.
Chair.
Sorry.
Just a pause, Mpofu. Just a pause.
Okay, without even finishing my sentence.
Advocate
Sorry,
Bao.
I'm sorry I interrupted you. Finish your sentence, Advocate Mpofu.
No,
Sorry,
fine.
Chair, I mean,
No, I've now recognized you.
sorry, Chair, I thought that maybe in not wanting to get into an argument or debate with my colleague, that maybe it should be appropriately stated to the witness that it's not just a member of the executive, but it's the president.
Yes, well, even worse, yes,
Okay.
that's correct. Even worse, the president, the most powerful member of the executive, thank you, has the power to suspend the ombudsman. And in our situation, in an act that one of our courts has labeled as retaliatory, because what had happened is that the public protector had issued certain questions to the president, and then she was suspended the following day. But that's the background. But the question I was putting to you is a more general, without getting into the specifics of that case. I'm saying in terms of the what you call the standards, the accepted standards, and the need for protection, which you have emphasized. Would you say that situation where a member of the executive and the most important member or most powerful member of the executive has got that power without even, and I think it's in one of the countries, we'll come to that, without even having to get the confirmation of parliament, for example? Is that a good thing? Sorry.
I will state that according to ombudsman standards, we talk about the principles, applying the principles of natural justice,
Mhm.
and we insist on procedural fairness in our work. And this insistence on applying the principles of natural justice and procedural fairness does not just extend to the ombudsman when the ombudsman is investigating.
Mhm.
It extends to the relationships of the ombudsman and his members of staff.
Mhm.
Whatever he does, he must be guided by the principles of natural justice. Those are our tools, our working tools. And by the concept of procedural fairness at all times.
Mhm.
And even in our administrative interactions with, whether it is the executive, whether it is with the judiciary, or whether it is with the legislature, that is the standard that we use. And if that is the standard that we use, then I expect that the different arms of government will recognize that, and they will also insist on adhering to the same high standards of procedural fairness. But of course, it's a work in progress. In all jurisdictions, it's a work in progress.
Yes, thank you. All right, maybe let me put it this way. Again, if we try to keep it at the general level, let's assume you have 3 countries. Let's call it country A, country B, and country C. In country A, before the public protector can be suspended, there is a system where you have to get confirmation from parliament. And as I say, I know it's one of the countries, I'll give you that example. Okay, so that's country A. In country B, there has to be, or rather, even the suspension itself is done by an independent body of judges or whatever, whatever independent body. And in country C, the president can just suspend you without those 2 protections. Which, according to the things that you are telling us, which of those is the worst system?
Of course, the third one is
Yes.
the worst system, but I must state that because we're talking about the institution of the ombudsman, it is absolutely necessary when any of the arms of government is dealing with any issue regarding the ombudsman, that procedural fairness must apply, because the ombudsman is in a very vulnerable position. As I said before, the ombudsman investigates the executive.
Yes.
So it's absolutely necessary to accord the ombudsman the highest levels of procedural fairness available. It's one person operating in an office as a legal entity. And the responsibility of making final decisions for all the investigations in the institution lies upon the shoulder of that officer. It's not easy. It's very, very stressful, speaking from experience. So the ombudsman must be accorded the highest level of how should I put it? Administrative and legal support to ensure that there is procedural fairness when any issue to deal with the institution is under the purview of any of the arms of government. So you said in the first instance, where there is a suspension, which is subject to a process and another process. So I would suppose that first that process must be completed before any decision can be made to accord any sort of decision with regard to that office holder. And in the second instance where the body is completely independent, I assume that all the proper procedures are in place, and the office holder would not have any complaint really with the process. And then with this country, you see where the president just suspends arbitrarily. Obviously, there isn't a proper ombudsman system in place.
Yeah.
You can't even really categorize it as there being an ombudsman in that country if there is such a situation.
Yes.
And I would say that we have had applications like at the International Ombudsman Institute from countries where the ombudsman is appointed and dismissed by the executive. And normally, according to our criteria, we don't accept membership of such countries.
Okay, thank you. You've taken me to my next question. So again, we're talking about some country somewhere in the air. If it was to be found in that country, that something like what you and I have described, which doesn't really accord with how the institution of ombudsman should be run. Am I understanding you to say that that country might face the possibility of being expelled? Maybe that's a strong word, but at least not being accepted into the family of ombudsman institutions in the world. Let's say there was let's use your country. If in Zambia, tomorrow they come up with measures which clearly are not in accordance with the minimum standards, would that risk expulsion from IOI and that kind of thing?
Such decisions are not taken very liberally. There's usually a lot of toing and froing.
I assume the toing and froing is done. So then what would be the worst thing that could happen?
Yes,
such
the
a case?
worst that can happen is expulsion.
Okay. Thank you. Now, you talked about reprisals
Yes.
as one of the, and we're still on the subject of protection. Looks like one of your themes is that there must be these instruments if you summarize them, all call for maximum protection of ombudsman incumbents and offices for the reasons that you've explained, because the office is inherently vulnerable and it investigates very, very powerful people
Yes.
now and institutions. Yeah. This is what I want to get at, and I'm just cutting to the chase so that I can be sure that my country is not going to be expelled. We have the following situation here, and if you go to, oh no, let me start by saying this, which is more important. Is it correct that in your explanation of the separation of powers earlier, you said that Parliament, and again, we're talking in general terms, should actually be protecting the public protector?
Let me start by saying that, of course, there are different systems the world over. But if we're talking about the classical model, the ombudsman is accountable to Parliament, is appointed by Parliament, and can be dismissed from office by Parliament in the classical model. Yes. Now, I think it was not envisaged that a situation would arise where an ombudsman really needs to be disciplined unless they've really grossly misconducted themselves, because the way the classical model is designed, the ombudsman has the unfettered powers of a judge during the course of investigations. So in order for you to be able to get the information, to get the evidence, you have to use those powers until the point where you are issuing the reports. Then those powers drop from you. You issue a report where you only make recommendations. And the reason why that is so was to prevent the ombudsman from always being in continuous litigation if they were made to have binding powers. And also, the second reason is just to ensure that there can be no acts of retribution from the executive, no harassment, because then the recommendations are just so. They are recommendations. If the executive wants, they can ignore those recommendations. And then the ombudsman now has the added protection of going to Parliament to say, I issued this report, and the respondent is not willing to implement the recommendations. And then it would then have to be up to Parliament to send this matter to a committee, which would then engage the respondent institution to ensure compliance. So in a classical model, it was never envisaged that the reports of the ombudsman would have to go to as far as the courts, really. Yes.
All right. Maybe let me ask it differently. Of the three arms of government, who should protect the public protector?
The reason why we say the office of the ombudsman should be accountable to Parliament is because through the system of checks and balances of the separation of powers, you want to ensure that the ombudsman reports to a body which it does not investigate. And that is the protection that is accorded to the ombudsman.
So which of the three should protect the public?
The legislature.
Thank you. And if you put it crudely, the legislature should protect the public protector from who? Who is, or maybe let me ask it differently. Which of the three arms is most likely to pose a threat to the public protector?
Because the ombudsman investigates the executive, so the executive is the branch that is most likely to erect these barriers to the work of the ombudsman to ensure that the ombudsman does not work effectively. But I must state here again that the judiciary also offers a protection in that it gives the office of the ombudsman the powers to make all the orders of a which are equivalent to a high court during the course of investigations. So these two protections work very well. And that at the end of the day, the report doesn't lay hidden in somebody's desk. It has to go to the legislature to ensure that it is it gets compliance from the executive.
Yes, thank you. So if we then summarize it, you're saying the executive is most likely to pose a threat, correct?
Yes.
And the primary protection should come from the legislature.
Yes.
Correct? But also the judiciary should also play a part in the protection.
Because it gives the powers.
Yes.
It gives the powers to the ombudsman.
Yes. Now, what happens in a situation? Okay, our favorite country somewhere in some continent. What happens in a situation where now you have a situation where the legislature, that is supposed to be the protector of the public protector, and the judiciary, that's also supposed to be the protector. Or let me put it this way. The legislature actually takes judgments from the judiciary and says, these are binding. We're just going to plonk them. Sorry, that's probably Afrikaans. We're just going to transplant them and you're gone. In other words, the two arms that are supposed to protect you, then wittingly or unwittingly collaborate to the one just borrows from the other some ready-made product and is the conduit pipe, and then you must be removed. Is that country complying with what should be happening?
The legislature, in this case, in the way that the classical ombudsman operates, the legislature is supposed to only come in to scrutinize the ombudsman in an instance, as I said, where there is, gross misconduct, but in the constitutional performance of the office of the ombudsman, I think the aspect of upholding the Constitution comes in my view, because the Office of the Ombudsman is accountable to Parliament and lays its reports before Parliament. And it is at that point that they can comment and say to the Ombudsman, we do not agree with this report, because they can refuse to implement the report. They can refuse to implement the report. But for when I assume, like even in my jurisdiction, I'll give an example of my jurisdiction. When a matter comes before my office and I issue a report, it is a binding, I do not issue recommendations, it's a binding report. But when it goes to the courts of law, because now it's binding, I don't even need the legislature to enforce that matter. So when the respondent appeals, if I make a finding against the respondent can go to a court of law. And when it goes to the court of law, if it goes against me, I don't think that, because that is it's the normal process. You are trying to exhaust the administrative channels of appeal. The respondent is trying to exhaust the administrative channels of appeal. And I don't see the reason why that judgment should go back to the legislature.
Yes, okay.
The respondent is allowed, it is his right to exhaust the channels of appeal, to go through the court process and go through the channels of appeal.
Yes, okay, let me ask it more directly. Is a country that allows a system where a product from the one arm of the state, the judiciary, is simply transplanted into Parliament and used to remove an ombudsman, a good system?
I would say that the checks and balances then are not working properly, because if a matter goes to court and a judgment is made, what is the reason to reinforce it again? I don't know. Maybe I don't understand the question. But as far as I can see, the normal checks and balances of the three arms of government should not cross over unless, I don't know. I'm not privy to maybe the legislation
Okay,
and the.
all right. Let's cut, let me stop talking about some country somewhere else. Okay. Here, in this inquiry, and I may be wrong about the numbers, 90% of the charges are directly based on court judgments, which are brought here. And we were told on the first day when we got here that those court judgments are binding. And so I don't even know why we're here, because if they're binding, then I suppose we should have just wielded the X on day one. Yeah. But that's a separate issue. I'm saying that, is it a good thing that a public protector or an ombudsman can be removed on the basis of 90% of the material or more? That might even be underestimated. That comes directly from the judiciary into an inquiry, and then it's just tick box. Okay, the judge said you did this wrongly, therefore you did it wrongly. The judge said you did not give this one a hearing, therefore you didn't give them a hearing. The judge said you were biased, therefore you're biased. Off you go, chop the head. Is that what was envisaged in the instruments that you've described?
The ombudsman, by the very nature of their work, the fact that they investigate the executive, when a matter goes to court and the matter goes against the ombudsman, I think it is the system is cleansing itself well because the reports of the ombudsman are being put up to scrutiny
Correct.
by the courts of law. And the courts of law are able to say, no, here, ombudsman, you were wrong. And it is also a way of ensuring excellence in the work of the ombudsman. So there is no reason why when the courts do their job, they've done their job. They've said, ombudsman, here you were wrong, or ombudsman, here you were right. They've done their job. The system has cleansed itself. I don't know. I don't see the reason why it should be taken up by another arm of government again. I don't know. That is my view. That is my professional view. That there is no need for, the system has cleansed itself. And if that ombudsman is an ombudsman who is aware of the principles and ethics of their job, they will take note of what the courts are saying
Good.
and implement it in their work to ensure that it doesn't happen again.
Yes, good. So okay.
Maybe Advocate Mpofu, if we can pause,
Um,
unless you want to throw
Chair,
a small
can you
question.
just give me one question just to wrap up that point so that we don't forget it. Yes, okay, let me go back to my old system. You have two countries. In one country, what you have just described happens. The judges make their judgment, and as you correctly say, it should be a learning tool for any public protector. Once a judgment says this and so on, and assume it has gone all the way up to the highest court, so it can be changed. So it's now becomes a learning document. So that's what happens in one country, and it ends there. In the other country, it doesn't end there. That judgment is taken and used by the legislature know-how to now do more than what the courts have done, to actually remove the person. Which of those two systems is better? The one where it's used as a learning, it goes its full course and it's a learning process. And as you say, hopefully it doesn't happen again. Or the one where it's taken as a weapon of mass destruction.
I think I'll just state that this is the reason why the international ombudsman world has insisted on ombuds standards. If we are to apply the standards when we are setting up, from the time we are setting up ombudsman institutions, if we say, okay, it's a pity that like, for example, all the standards have come way after ombudsman institutions have been established, but still there is a way of correcting our constitutions. There is a way of correcting our legislations. If we adhere to the standards, then such a situation should not arise.
Thank you. Thank you, Chair. We can have a break. Thank you.
Thank you, Advocate Mpofu and Advocate Sokoni. We'll pause for 15 minutes break and be back at 1:45. Thank you.
Thank you, Chair.